very welcome to this session of the privacy platform, as we call it. And today the title is The Cloud Act and E-Evidence. Is this America first or GDPR first? I think this is a very hot topic. Some of you may have followed the little exchange of views we had yesterday in the Civil Liberties Committee in the European Parliament with Commissioner Jourova, who is responsible for e-evidence, but also the negotiations with the United States. We were informed that the mandate for negotiations is about to be finalized, so this is all very exciting. But as you can imagine, we have some very serious question marks over the whole thing. Going back a little bit, you will remember the Microsoft case, where Microsoft had been told to hand over data, but told by the American authorities to hand over data that were stored in Europe and therefore governed by EU law. Microsoft challenged that subpoena, went to court. A lot of members of the European Parliament, including myself, joined your case, but then the whole thing basically was overtaken by the adoption of the US Cloud Act, which was part of, I believe, some budgetary exercise. In any case, it wasn't an act that was properly discussed, not even in Congress. In the meantime, we also learned that there seemed to be internal discussions going on in the Council of Europe about revising the Budapest Convention, also in the direction of removing AMLATs, removing basically, let's say, judicial approval and the requirement of court orders for obtaining evidence. So we see that everything is moving in the same direction, and I think it is very urgent that we have a broad debate about this, and not just between policymakers, but this is something that concerns every single citizen. And I personally think, and this will come as no surprise to you, that if we have such a system within the European Union, I mean, that is something that is, as a principle, to be welcomed, provided that we have the matching safeguards at the same level, which at the moment we do not have yet. But what is really a red line for me is that third countries, with governments that I was unable to vote for, have access to my data here in Europe when I expect to be protected by European laws. I find that unacceptable, totally unacceptable, and I also think that the argument that MLATs are too bureaucratic and cumbersome is not a very strong argument, because then, you know, fix the MLATs. But also I think in a democracy, yes, we have certain hurdles in the procedures which are actually meant to protect people. So there's a reason for that. Which is not to say that we shouldn't be looking for ways to improve and strengthen law enforcement. I'm not saying that, but I think we have a very broad and exceptionally interesting panel here today, representing different views, different interests, and we also, well, let me start by welcoming in particular Mr. Mark Gray from DG Just in the European Commission, who I hope is going to tell us a little bit more about this famous mandate that we're all looking forward to, and which I also believe should be made public, not just available to the European Parliament, but public. Then I also very much welcome Mrs. Jennifer Daskal from the, let me not make a mistake here, the American University Washington College of Law. To my right, Mr. Guido Brinkel from Microsoft, and to his right, Mrs. Katitza Rodriguez from EFF in the US. Maybe I'm going to also ask you to do your intervention in that order, or do you prefer to start?
You start.
Yeah. Okay, Mrs. Daskal will start then.
Great. So thank you. I'm really honored to be here, and thank you for including me on this panel. So it was just mentioned, law enforcement access to data across borders is an increasingly significant problem. Data that's often important to the investigation of purely local crime is often increasingly found across territorial borders, perhaps in a location in which the target of the investigation has absolutely zero connection, and the only reason that the data is there is because a service provider with whom the individual contracts is located there or has services there. An EU Commission report that was released about a year and a half ago found that 55% of law enforcement requests involve data located across territorial borders. Now, the Cloud Act was enacted in part to address some of these challenges and some of these complexities. So what I want to do in my little bit of time here is to clarify some myths and hopefully establish some of the reality about what the Cloud Act is and what the Cloud Act does. So myth number one, as everyone here knows, the cloud is not actually a cloud, but I couldn't help using this imagery. That's not really the myth. Myth number one is that while it's true that the Cloud Act was added to a big budget bill in the United States, it was not kind of snuck through at the last minute as has often been described. It was the subject of 3 different congressional hearings. Pieces of it had been submitted to Congress by first the Obama administration and then the Trump administration. And it was part of big chunks of it, big pieces of it, were parts of very active and ongoing and long-standing dialogues between industry, members of civil society, a handful of academics, and government officials as well. So the Cloud Act has really 2 parts. The first part deals with the question of U.S.'s ability to reach data pursuant to its compelled disclosure orders. These include warrants, they include other forms of compelled disclosure orders. And the Cloud Act clarifies that when the U.S. government issues one of these orders on a U.S.-based company, that company is required to disclose all data that's in the possession, custody, or control of that company, regardless of where the data is located. And so this leads me to myth number 2. This does not allow the United States to reach out across borders and issue warrants or other disclosure orders on European-based providers that lack a presence in the United States. The same jurisdictional rules that applied before the Cloud Act continue to apply after the Cloud Act. And again, to access the data, the United States needs to abide with the relevant process for content that's a warrant based on probable cause issued by a judge with the requirement that there's particularity as to what's being sought. This was, as has already been said, a response to the Microsoft Ireland case, which is very well known at this point, in which the Second Circuit, a circuit court in the United States, had said that Microsoft was not required to turn over content of communications, in this case emails, because they were held overseas in response to a U.S. warrant. But I want to emphasize that this case, this ruling, was an outlier. It was disagreed with by multiple other lower courts in other jurisdictions not bound by this particular circuit court. And it changed existing practice in which location of data had, prior to the Microsoft Ireland case, never been a basis for resisting the compliance with the warrant. And I would submit that this makes sense because we often, and the government often doesn't know where the data is. Data moves around with some regularity. There's often no connection between the data being sought and the individual whose data is being sought for investigative purposes. And it's not really a key relevant factor for considering the equities in stake. And I consider those equities to include the privacy rights of the individual target, the security interests of the investigating state, and to some extent the sovereign interests of states in controlling access to data of their own residents and citizens. Now, that said, the first part of this Cloud Act also recognizes that in some cases, this request for data without regard to where the data is located can create a conflict of laws. And it added two important additions, and I would argue that these are improvements over what was the existing law. First, a new statutory provision that authorizes a provider to bring a motion to quash based on conflicting laws. Now, this is, albeit a very limited provision, it only kicks in if the request deals with data that's located in the jurisdiction of a qualifying government. A qualifying government is a government with which the United States has a separate bilateral agreement. We're going to talk about that in a second. And currently, there's none. There's no such governments. And it also only applies if the U.S. is seeking the data of a foreigner located outside the United States. But what's interesting about this is that it represents a shift from thinking about the location of the data as a controlling factor to the location and the nationality of the target. And as for the reasons that I said before, I think that's a shift that makes sense. That if the United States is seeking the data of an individual who is located outside the United States who is not a U.S. resident, then there's much more justification for taking into account, considering, respecting the foreign laws of that individual. And importantly, the legislation also includes a savings clause that explicitly preserves the availability or application of what's known as common law comity. This kicks in when there are, in fact, conflicting legal obligations between the U.S. obligation to disclose and a foreign government's rules which prohibit disclosure, and if such a conflict exists, then the courts will weigh the relevant interests in deciding how to proceed. So that's part one of the Act. Part two of the Act deals with the issue of foreign governments seeking to access data that's held by U.S. service providers. So there are provisions of U.S. law, the Stored Communications Act, that prohibit U.S.-based providers from disclosing content of communications directly to foreign law enforcement. And this has become an increasingly significant source of frustration for a range of foreign investigators because of the fact that they are required to then use the mutual legal assistance process even when they are seeking data of their own citizens or own residents in the investigation of local crime. And this is a time-consuming and laborious process, and given the kind of exponential increase in data across borders and the interest in data across borders, not something that will very readily or easily be solved simply by adding more resources to the MLAT system. And so what the second part of the Cloud Act does is it authorizes the executive branch with a range of conditions to enter into bilateral agreements with foreign governments that would allow those foreign governments to make direct requests to US-based providers for data in the investigation of serious crime. Now I'm going to talk for a second about the range of criteria and limitations on these agreements. So first, before a country can even enter into such an agreement, it has to be certified by the Attorney General and the Secretary of State in the United States as being human rights and rule of law compliant. And then the Cloud Act itself includes a number of specific limitations on the requests that can be made. So they have to be particularized about a particular account, person, or device. They have to be based on reasonable and credible facts. They have to be subject to oversight or review by a court or an independent judge or authority. They cannot be used to infringe the freedom of speech. They have to be for the purpose of investigating serious time. The data that's turned over is subject to a range of secure storage requirements and limitations on who can access that data and when that data can be disseminated and how long it can be retained. And it's subject to requirements that non-relevant information be deleted and sealed and not disseminated. Finally, again, this reflects this idea that of a shift from a focus on the identity of the target as opposed to the location of the data. These types of direct requests are only available for foreign governments seeking the data of somebody who is located outside the United States who is not a US citizen or a legal permanent resident, under the idea that if a foreign government is seeking that data, the data of somebody in the United States or a US citizen or a legal permanent resident, they should continue to be required to employ the mutual legal assistance process and effectively rely on US legal standards. And finally, these provisions require that that partner governments adopt reciprocal provisions, which means that the foreign governments would be required to lift any restrictions or avoid any restrictions on US-based requests to foreign-based providers. Now, myth number 3, this does not give the US ability to reach into European providers and demand European providers turn over data. There is no existing authority under US law for US law enforcement officials to issue warrants extraterritorially. There's no authority for US law enforcement officials to issue a warrant demanding a non-US based entity to turn over data. And unless there's a change in US law, the existence of Cloud Act agreements will not change this. The other key piece that I want to emphasize is that the conditions laid out here are merely floors. Any bilateral agreement can, and I've argued previously and continue to argue should add additional requirements. So this is a real opportunity to set rules on a bilateral basis and standards governing access to data and establish some sort of minimal floor and minimal standards that countries around the world should meet. Before I end, just one quick question that arises and that's going to arise is a question as to whether or not there can be agreements with the European Union as a whole. The Act itself refers to agreements with a foreign government, suggesting that they need to be done on a bilateral basis. But as I have argued and have written with Peter Swire, who is somewhere in the audience here, right there, we have suggested that it is possible and preferable to set up some sort of framework agreement between the US and the EU that sets out the minimal standards that each country would have to meet in order to be able to enter into a bilateral agreement. And finally, I'll just end by saying that we're seeing some really interesting trends here. The link between territory and property, at least data and sovereign interests, is being upended by the way that data moves around. And the way in which companies decide where and how to store their data. We're seeing really the rising party of third-party players to delimit and determine access, which is what this is all about. And there's really a need for new forms of accountability, increased transparency, and I see this as a prospect of using these types of agreements and other new forms of innovative tools to both facilitate access and to set, uphold, and raise the baseline standards.
Okay, thank you very much. I can see that there's plenty of material for debate. I'm going to fairly rudely ask the other speakers to really limit your intervention, because it's now 1:30. We have 45 minutes left. And we also want some time for questions and debate, and you'll have plenty of opportunity in your response to the questions to make some further points. If you can really stick to 7-8 minutes max. Mr. Brinkel.
Yes, thanks for having me, Sophie, and thanks for inviting Microsoft to share an interesting perspective. My impression from a German perspective is a bit that we had a bit of a slow start on this debate in Europe, but we're really gaining momentum now, and I think this conference is a good example for this. I think we have more than 4 panels here discussing these issues. So at Microsoft, we're really glad to see this now top of mind of European policymakers and also the data protection community. I want to start with some reflection on the general importance of this debate. First, this is not a regulator versus industry battle. Why? Because the legal uncertainties on the table, the legal uncertainties of the current regimes are not only affecting industry, they're affecting the law enforcement authorities, also the data protection authorities in the very same way. And second, it's a very complex legal file. You could start a PhD with no problems on this file. There are several starting points for this type of legal analysis. But at the same time, it's not just a nitty-gritty technical dossier, because, and I think Jennifer's introduction already outlined this, these proposed rules, be it e-evidence, be it the Cloud Act and all the related issues, lead inevitably to questions how to practically enforce fundamental rights in the context of government access to data, to questions how to achieve international standards and protecting the rule of law, very fundamental issues at the table. And finally, the underlying challenges we are discussing here, conflict between jurisdictions, and as a consequence, need for modernized or new forms of international cooperation, are very likely the vanguard of very similar debates we're going to see in other regulatory areas over the next decade. So as an impulse for our discussion today, I don't want to step too much into the details of single provisions of the evidence or the Cloud Act, but I want to focus on two rather political fundamental aspects that are very important for us from an industry perspective. And the first one is the reciprocal nature of all these issues and the need for international agreements to address this reciprocal character and to provide a practical path towards effective legal safeguards in this context. I'm sure you all know that Microsoft has a bit of a prominent role in that current debate, since with the Rowan case we actually have at least indirectly spurred the legislative initiative that eventually led to the Cloud Act. Sharing a German perspective, the evidence proposal in Germany is partly considered just as the European answer to the Cloud Act. And I think at the outset of this discussion, it's important to recall that this is actually not 100% correct, because when we look at the legislative history, it reaches back to 2016 with the first Commission non-papers. The evidence as its core is a response to new technology realities and the challenges authorities and the legal frameworks, the current legal national frameworks face against the spectrum. So what are these new realities? First, the communication landscape is becoming more and more fragmented. Customers are using a variety of communication services simultaneously today. And as a prosecutor, German prosecutors in a talk said, prosecutors have lost their one-stop shop, their state telecom incumbent, which they had in the 80s. Second, cross-border is becoming the new normal. Technologically, even a voice call from Brussels to Brussels might be a cross-border service today. Third, the existing national legal frameworks are not fit for these new circumstances. Again, speaking for the German framework, the territorial scope of the relevant provisions in the criminal procedural law are just not defined precisely their territorial scope. And the last point, and maybe the most important one, the remedy for this, developed decades ago, mutual legal assistance, is at least practically broken. So that's the situation. So for communication service providers in that context, confronted with disclosure orders for data stored abroad, be it from Europe to the US or the other way, we are actually maneuvering between lawful access frameworks, national ones in the current framework, and the blocking statutes in the data protection law in the other jurisdictions. And this interplay between the LIA competences on one side and the blocking statutes on the other side are the main reason why the overall system is a reciprocal one and why every political answer in the end must be a reciprocal or mutual one. So there are mainly two approaches to address this challenge of reciprocality. The first one is comity clauses and the second one is bilateral agreements. So for the explicit possibility to change orders on a comity basis, we think this is really a huge step forward, and we are welcoming these elements in the Cloud Act as well as in the evidence proposal, particularly in the Commission's proposal. But at the same time, we need to keep in mind that both the Cloud Act and the evidence leave open the principal possibility for courts to determine that obeyance of a disclosure order would violate foreign law, while at the same time uphold the very same order as a result of a broader balancing of interests. And on the European side, this is particularly true for the Council's general approach, which has deleted the Article 15. So the political implication of this situation, where a state court in one country orders eventually the violation of the law of a foreign country, are really severe. And I think it's fair to assume that for that reason, this specific situation will possibly only occur very rarely in practice, but at Microsoft we think that we shouldn't rely on this assumption, but we need to proactively address these potential conflicts and establish the necessary legal safeguards via mutual agreements. The Cloud Act, as Jennifer has outlined, has created the foundations for these new type of agreements on the US side. And as a closing, Microsoft has already outlined what we think these agreements, as well as actually the legal frameworks, I think you cannot really kind of separate this in the end, what these should entail, and we have outlined 6 principles. I think it's fair to say that we are not calling for fussy political commitments, but really practical legal safeguards. So I just want to close my remarks with an outline of some of these principles. You will find the detailed paper online. The first is that we think, except from very narrow circumstances, users should have a right to know when governments seek access to their data, and service providers, as a consequence, must have a right to tell them. In practice, this means that we think the secrecy of orders should be the strict exemption and not the rule. And this is important in the current debate when you look at the Council's approach, because it has dropped exactly this principle which has been established in the Commission proposal. We have litigated this in the US, by the way, heavily, and our lawsuits have already prompted significant new protections. The second is that, from our perspective, and this is particularly, again, relevant when you look at the Council's approach compared to the Commission's proposal, we think that service providers are a crucial element in the system of checks and balances. And thus we think that you don't need only prior judicial authorization, but also as an additional element, service providers must be able, via clear procedural and substantive rights, to challenge orders which are overbroad. And in this respect, the Council's general approach is highly problematic because it removes substantially exactly those safeguards. And the final point is that we think that transparency should not be only guaranteed on an individual level via the notes, but also as a general principle, that means that we think that the possible agreements in the future should be transparent, that they must be published prior to the adoption to enable a public debate. And second is that we need rules and guidelines for statistical transparency, that we need rules and guidelines for transparency reports. So let me close with an answer to the title question, America first or GDPR first? I think the answer is, of course, neither or no. What we need is a system of checks and balances of mutual trust, and we not a system which plays off law enforcement against data protection in the end.
Okay, thank you very much. Mr. Gray?
Thank you very much, and let me begin by thanking you for the invitation. I think I'm going to try and cut quite substantially what I was going to say, because I think both the opening 2 speakers have set out essential elements of the key background. But rather than simply starting on the question of conflicts and law and cloud e-evidence, bear with me for a moment. I think we really do have to bring it just back one step. And this is not just about law. This is about people. This is about operational need. And it is about real-life cases, whether we're talking terrorism, whether we're talking child pornography, whether we're talking hate speech, fraud, data leaks, etc. What we are talking about here is putting in place a system where we have rules to better catch criminals who have left that electronic trail. In quite simple terms, this is about how we put in place an ability to catch those criminals, but all the necessary safeguards that are necessary, not just in terms of safeguards for suspects, but I think it's also important to say, we have a duty also to the victims. It's not just a question of looking at how we look at the individual procedure. Now, of course, we all know background. We have the existing judicial cooperation between judicial authorities, we have MLAT, we have the European Investigation Order, but also I think we have to recognize the shift that we're seeing. If we look at mutual legal assistance, we're dealing each year with a few thousand cases. If we look at direct cooperation requests on a voluntary basis, we're talking about well over 100,000 requests. Now that is the reality on the ground. So much as I would love to say MLAT is the solution, the simple reality we face is that in terms of investigations, in terms of when you speak to practitioners, what we're seeing is a different reality on that ground. So I think then the question, of course, comes, how do you respond? And here we have to be, I think, quite open. The United States has got a law in place. The European Union has not yet got a law in place in terms of e-evidence. Of course, and I think here very important, we have the general data protection rules and the very specific rules that are set out in Chapter 5, also in terms of transfer to a third country. I'm not now going to set out the whole e-evidence proposals. I think you know the essential elements, the European Production Order, the Preservation Order, the legal representative, etc. And I think we also have to recognize that when we look at the Cloud Act, we do not yet know exactly how US judges will apply the terms in terms of scope. I very much note the comment from Jennifer on this is not targeted in terms of against European companies. I think it's an important point. But of course, we will have to see how US judges specifically apply the scope. In the European Union, of course, we have the data protection rules as the first level of protection. But with the US cloud in force, on the European side, data protection in force and not yet e-evidence, there is that risk of conflict of laws. In terms of the Commission approach, I'm in this wonderful position, and there's a few people in this room, being a civil servant, trying to present something that has not yet been adopted at a political level, which is always fun. But I will do my best just to give a few elements. We have to put this in the bigger picture. Next week, the Commission will present two mandates, two negotiating directives. The first for the second additional protocol for the Council of Europe Convention on Cybercrime, Budapest. And here we have to recognize the reality that much as we like to talk about international agreements in terms of bilateral agreements, there is that multilateral context. And there are a few people in this room who are spending many hours of their day worrying about the exact arrangements that will be agreed at that level. And we should not be naive. The European Union's position is not automatically going to be the one that's taken up in Budapest. So we have to recognize that reality. The second mandate that the Commission will present next week will indeed look at the question of an agreement between the European Union and the United States. I think it goes without saying, based on our own internal rules for the European Union in terms of what the Commission has presented, we see a number of key elements there, of course, removing the conflict on content data, essentially addressing the bar that currently stands from US service providers responding to requests on content data from foreign law enforcement authorities. The second, I think, clear advantage of an agreement, and the one that in some ways I think people miss, is they're so focused on the content data.
Not 2 minutes, please.
Yeah. Focused on the content side is how we bring more legal certainty to that issue of non-content data in terms of the voluntary requests. And that is one of the issues that will, I think, be there in terms of how we move forward. Of course, I haven't yet mentioned the word safeguards. One of the key elements of an EU-US agreement would be to ensure that the safeguards in the EU-US umbrella agreement are applicable and that you address the issue of specific safeguards, because the EU-US umbrella is judicial authority to judicial authority. How you address the specific issue of direct cooperation with service providers. Just to conclude, I will repeat what Commissioner Jourova said last night in the Libe Committee. The Commission's starting point is not, I repeat, is not to enter into negotiations with the United States under the terms of the Cloud Act. Our starting point, the way we approach these negotiations, is by looking at the e-evidence package, but also, I think, a recognition that any agreement we reach with the United States should be EU-wide. I often look at the whole question of should there be bilaterals between individual member states, the whole certification procedures in the Cloud Act. It's a little bit like, the best analogy I can come up with, it's a bit, if you go down the route of certification under the Cloud Act, it's a bit like winning a match or the Super Bowl, and then being told that your players aren't actually eligible. So I'm not sure we are so keen to go down the route of bilaterals. I think there the Commission's position will be very clear. It should be an EU-wide agreement concluded with the United States. Thank you.
Okay, thank you very much. And Ms. Rodriguez, last speaker.
Thank you. It's an honor to be with you this afternoon. On behalf of the Electronic Frontier Foundation, I would like to thank Sophie for the opportunity to speak today. As you may guess, EFF analysis of the Cloud Act starts from a slightly different point of view than our previous speakers. Certainly, we will have a much more explosive event here if Microsoft, EFF, and the United States government agree on everything. That's not to say we don't sometimes agree. If not very often with the United States government, then occasionally with Microsoft. We supported them in the Microsoft Ireland case against the United States government when we argue together with Microsoft that the United States search warrant does not authorize the access of the communication of Microsoft users stored in Ireland. And we, at least, still hold to that position. The US Cloud Act represents a different compromise between American tech companies and the United States government, a deal whereby Europe and potentially many other countries are offered the possibility to faster access to the content of communications held by American companies. In return, the United States government obtained a fast-track access to the content of communications of the world's data collected by American tech companies, even if the data is stored in Europe or any country outside the United States. Unlike our previous speakers, we don't believe that it's a good deal for Europe. The Cloud Act is a solution to the lowliness and underfunding of the US side of the MLAT system, a problem that was not created by Europe. It was written as a horse trade between tech companies who were worried that foreign countries would introduce their own solutions to this problem. And the United States government, which sought an opportunity to legally define new powers over the rest of the world for a low domestic price tax. It's been presented as a gift for Europe. To mix many English metaphors, you should look this gift horse in the mouth. Let's focus on the extraterritorial warrant provision of the Cloud Act. Because the US-based companies host and carry much of the world's internet traffic, this specific provision will allow American law enforcement agencies, from local police to federal agents, to serve an extraterritorial warrant to American and possibly foreign companies who the US will decide have a sufficient jurisdictional nexus with the United States. So American law enforcement can access the content of communication of any persons in the world whose data is stored in the European Union or any other part of the world. If this had been the judgment in the Microsoft Ireland case, we will rightly be up in arms. But when presented as one part of a potential deal, it has been apparently acceptable for some. But there is no true deal here. Whether or not the EU signs an agreement under the Cloud Act, the United States has in its law already asserted its right to access the world's data collected by these American companies, no matter where the person or the data itself resides. If the European Union chooses not to enter into an agreement with the United States, that won't stop the United States from using their extraterritorial authority. But American companies will only have the possibility to object or move to quash this request in cases of conflict of law if a country has entered into an executive agreement under the wording of the Cloud Act. Of course, just because the United States believes it has the power to make such demands and has embodied the belief in the Cloud Act, does not mean that it's lawful elsewhere. Organizations like CSPS and EDRI have raised doubts whether the US service providers whose data resides in the Union could lawfully transfer data exclusively based on the warrants issued under Cloud Act if it's done outside of any international agreement. Article 38 of the GDPR on transfer of personal data to a non-US European states ensure that even in the extraterritorial application of American domestic law, American authorities may not undermine the protection that in the Union is granted to all persons. And an infringement of this provision can be subject to a 4% of a company's total worldwide annual turnover. And while Article 49 allows for certain derogations to mutual legal assistance, this provision does not seem to justify all transfer of data ordered under the Cloud Act, because transfer should be not repetitive and concerns only a limited number of data subjects. If the European Union decides to enter into agreement, how can the Union or member states ensure or confirm that the United States will use its new extraterritorial power to access content based in Europe under the same probable cause standard that the US used domestically for American? Remember that you have two-tier privacy protections. One for Americans, one for foreigners. But the fact that this two-tier system is embodied in the Cloud Act goes to the heart of a profound difference between current American models of privacy and European law. With the Cloud Act, the United States believed that there should be two different privacy standards, one for Americans and one for foreigners. We argue that, as with all human rights, privacy is a human right. We need equal protection without discrimination. The second part of the Cloud Act, the executive agreement, have been very much debated, but want to share a couple of additional thoughts. If the European Union enters one of these executive agreements with the United States, the Union could potentially wiretap people located anywhere on the globe, so as long as the target of the wiretap is not a United States person or located in the United States, without the procedural safeguards of American law typically given to data stored in the United States, such Title III warrants or even notice to the US government. That this means that in a potential US-UK agreement, post-Brexit, the UK will be able to wiretap Europeans, individuals, whose data is collected by American tech companies, and those, and those foreign companies subject to the United States jurisdiction, following the legal standards. The Cloud Act does, if it's true, authorize a certain minimum legal of protections that countries must adhere. But those standards do not rise to the high level of protection the United States offers its own citizens. And will always be the case, the US government will be the judge of whether a country reaches those standards. The Cloud Act is the United States to attempt to impose its de facto view of global privacy rights on the rest of the world, forcing countries to either participate in the US scheme to bypass mutual legal assistance or risk zero oversight of how the US law enforcement access data in a country. A possible agreement between the US and the European Union can also create a potentially dangerous and coordinated race to the bottom of privacy protection. It's true we want to make things faster, but no matter how far we go, we also need to be safe. You can make a car go faster by making it lighter, by throwing out the seatbelts, the speedometer, the windscreen, and the airbags, but isn't the best way to make secure and safe cars. Perhaps a dual privacy regime that meets the standards of both the requesting and the responding countries should be followed. Dual privacy protections will help ensure that the nations seek to harmonize their respective privacy standards. They do so on the basis of the highest privacy protections. Absent a dual privacy protection, nations may be tempted to harmonize at the lower common denomination. Gracias.
Okay, thank you very much. So now we open the floor for questions and debate, but I do feel the urge to make a couple of remarks here. My facial expressions were probably a giveaway. No, I have a very simple understanding of democracy and the rule of law. Governments govern on behalf of the people. Sometimes they tend to forget that. They think they govern because they're in power. No, they're there with the mandate of the people. But the people also are entitled to protections against abuse, mistakes, arbitrary decisions. And so there's a connection between the powers that you give to government and the protections, the legal protection that comes with it. And the point here is that the powers are increasingly, well, they've been increased anyway, way beyond reasonable limits in my view, but that's something else. But powers, law enforcement powers, for example, government powers, are increasingly cross-border. And legal protections remain strictly local. There's a complete mismatch. And I have to say that the European Commission has not done a whole lot to repair that. And the point is, what you're saying, oh, but we're being totally reasonable here. Look, we've got all these safeguards. The point is, I can never hold the American government to account. I cannot vote for the American government. And if I could, Mr. Trump would not be in power. So there is a complete mismatch. So we're creating more and more powers, cross-border powers for governments, for law enforcement authorities, and the protections remain completely local, which in essence means that citizens are totally unprotected against abuse, against arbitrary decisions, and against mistakes of governments. Secondly, we're talking, of course, about the United States. An old friend of Europe, an old ally, But you cannot deny that our alliance has been subject to change, at least in the tone of voice. I mean, we were somewhat surprised to find that the EU had been downgraded in its diplomatic status just before Christmas, and we weren't even told about it. So, it's a bit strange that the United States grants itself jurisdiction on European soil and says, but it's okay, we're friends. I mean, sorry, we may be very friendly, but I also believe in rights. And my question to the Commission is also, what's your attitude going to be if there's going to be a Russia Cloud Act and a China Cloud Act or a Venezuela Cloud Act? Then third point, you're saying, oh, it doesn't concern European companies. I mean, we only target US companies. Yeah, duh. I mean, the US companies own, what, 98% of the market. So, we're still talking about all the data of European citizens stored in Europe. I'm a lawmaker. I have worked for 5 years together with my colleagues on the GDPR and the police directive, which the implementation of which is pathetic, by the way. And then you find that that's just overtaken by the fact that a third country gives itself jurisdiction on the continent that I live on. I find that unacceptable. I don't think any American citizen would ever accept such an attitude from the European Union. Then, about the safeguards. I was very much intrigued by the sentence that you used on your slides to describe this new mechanism. You call them MLET bypass agreements. Well, that says it all, doesn't it? I find that pretty shocking. And also, for example, even e-evidence within the European Union, I'm all in favor of the principle. But if on the one hand the European Commission is unwilling or unable or both to ensure that the rule of law is upheld in the member states, such as Poland and Hungary, and that the judiciary is independent, for example, then why would I trust an e-evidence system? And the same logic applies to the transatlantic dimension of this. And then finally, when it comes to safeguards, and the European Commission is talking about safeguards, making reference to the umbrella agreement, hey, that's the same European Commission that negotiated the PNR agreement, the SWIFT agreement, Safe Harbor, the Privacy Shield, and also FATCA, which are tax agreements. Well, you didn't actually negotiate that. You left it to the member states, which is even worse. So, so the point here being, do we want law enforcement authorities to have all the necessary powers to carry out their jobs? Yes. But if you strengthen those powers, then legal safeguards for citizens have to be strengthened at the same time, and they have to be at the same level as the law enforcement powers. So if there are indeed transatlantic law enforcement powers, then the legal safeguards and the rights and the legal protections have to be at transatlantic level as well, and they are not. So, okay, and no, maybe one last remark before I open the floor, because you were talking about legal safeguards, but what you really mean to say is legal safeguards for companies, not legal safeguards for citizens, which is something that we're concerned with. And I'm very happy that you get your legal safeguards, but I think the protection of citizens is a tad more important here. Okay, having gotten that off my chest, I'm going to open the floor for debate. I'm going to take 3 questions, and then we come back to the panel. First the gentleman over there, then the lady in the middle, and then the gentleman, I think, in the back. I can't see here properly, it's a bit dark.
Hello, Tobias Moschers from Datenschutzraum Germany. We had a lot of attempts or successful abuses of law enforcement cooperation internationally in the last years, even in Europe. And my question is, if we strip down the safeguards to a level that is not even equal to that we have now, how do we detect those and prevent the abuse or something like that?
Okay, on abuse, lady in the middle.
Hello, my name is Andrea Lisievich. I'm a data protection attorney. And I obviously had a lot of questions written down, but a lot of them have been touched upon. And thank you very much, Ms. Veld, for saying, I think, what a lot of the people in this room have just been thinking. The main question from a lawyer point of view right now is, well, mostly addressed to Mr. Gray. How long do you think it's going to be until this philosophy of the Cloud Act of considering US holding companies as being in control of the data processed by their subsidiaries in the EU will lead to those US companies being considered joint controllers with their subsidiaries in the EU and being directly held responsible for breaches of the GDPR? And I'm not only talking about breaches of Chapter 5, because obviously the request from a foreign government is not a legal basis for a transfer, but I'm mainly talking about breaches of the transparency, breaches of data subject rights, and, well, basically all of GDPR. Thank you.
Okay, thank you very much. I think there was a person in the back there. Yes, over there.
Gloria González Fuster from LSTS in Brussels. I have two very short questions for the European Commission, of course. For the safeguards, if you could, when you elaborate the safeguards, please refer to this question of, is it for citizens, is it for everybody, as it should be? And then I know you cannot predict the future, but if you could just share your thinking about the Brexit problem and Brexit and this multilateral, bilateral, and what do we do then in this Brexit situation? Thank you.
Okay, thank you very much. Is there one more last question over there?
Yes, really a very brief comment. Peter Swire from Georgia Tech. Katitza talked about the high level of protection in the United States for before the government gets access. That includes an independent judge. It includes probable cause of a crime, a specific request, not general, and providers can go to court to quash. That's a higher standard than, based on our research, exists in most European countries before the Justice Department can touch the data. Why is that not considered an important safeguard in the debate?
Okay, who would like to answer first?
Let me, as I had a few, I'm tempted to start with the last one, Brexit. I think the UK has some slightly bigger issues to deal with at this exact moment in time. Of course, we're aware that the UK is in quite advanced discussions with the United States on a bilateral agreement. 5 minutes remaining. So we don't have 5 minutes to deal with Brexit, but I think you can be, let's also be clear, the UK and the US have not yet been able to reach agreement, and there's still quite a number of issues from what we understand to address. But of course, it will also depend on its status within the European Union should the United Kingdom wish to conclude an agreement with the United States. The moment the European Union puts a mandate on the table, there is quite well-known case law on the whole question of royal corporation. So I leave that to see how that one moves forward. I can't predict, indeed, the future. In terms of safeguards, what I specifically talked about, and something to look at next week, is the existing safeguards we have in place, and there you're talking privacy, data protection, and procedural rights safeguards. I think it's very important that you look at what currently exists, and the important here of course, we're talking here pre-trial, I mean, a particular situation. But it is also true, as I mentioned in my opening remarks, that when you conclude an agreement with a third country, of course, when it comes to specifically going directly to a service provider, you may need to look at what else is needed on top of the umbrella agreement, given that that is judicial authority to judicial authority. I think the one thing I wanted to say in conclusion, and I maybe come on the very technical point bilaterally, the issue here is how we get the balance right. Actually, a lot of what you said, Sophie, I don't disagree with. Question is, how do you get the right safeguards in place for people? Yes, there are safeguards for service providers, but actually what really matters are the safeguards for people. And therefore, if you do a third country agreement, how do you get that balance right? So I do agree with actually quite a bit of what you've said. The challenge for us is finding that balance between speed, because that is the reality, whether we like it or not, that is the reality of what's happening in terms of on the ground. How do you then ensure the necessary safeguards are in place? Commissioner for Justice and Fundamental Rights is not approaching next week thinking, how do I weaken safeguards?
Thank you, Mrs. Daskal.
So I'm going to pick up on that last point because I also strongly agree with the key question here is how do we both ensure lawful access with the appropriate safeguards? And I'm going to pick up on the final comment as well. So the two parts of the Cloud Act do that in two different ways. When law enforcement, U.S. law enforcement is accessing data, as Peter Swire just emphasized, they need a warrant based on probable cause approved by an independent judge for the investigation of a crime over which the U.S. has jurisdiction and with particularity over with respect to the data being sought. This is, as Peter also mentioned, really a higher standard than exists just about anywhere in the world with respect to the preconditions that apply prior to accessing data. The question as to what happens if and when that request seeks the data of a European held in Europe, and whether or not the GDPR prohibits that transfer is an open and ongoing question. The Cloud Act and pre-existing common law comity provide a mechanism for that conflict to be raised. And if and when there is a conflict, that should be raised. We have not yet seen any case in which anybody has asserted such a conflict, but it's something that I think we will see going forward, and it raises a bunch of really interesting issues. On the second part, it is an MLAT bypass system, and the reason why, and it's done explicitly, and that part was done at the request, at the behest of foreign governments who were increasingly frustrated by the fact that when they were seeking access to data in the investigation of local crime involving local targets and local witnesses, that they couldn't employ their own processes and their own procedures, complete with their own safeguards that were decided upon in their nation via democratic processes, or in some cases, unfortunately not. And instead, we were forced to go through the U.S. system and effectively get a U.S. warrant based on probable cause. Our research also indicates that in response to this problem, governments were increasingly seeking out alternative ways of accessing that information, either via data localization mandates that would allow them to access the data pursuant to their own rules without any sort of additional safeguards put into place, through other potentially surreptitious means of
We started 10 minutes late because the room wasn't liberated. We have 3 more minutes.
And via other potentially surreptitious means of trying to access the data. So the Cloud Act, the conditions of the Cloud Act set a floor, and I would argue, and I think a range of research suggests that the floor of conditions, if they were adopted globally, would actually raise safeguards and raise protections pursuant to the status quo. I also want to emphasize, I said this at the end, the conditions in the Cloud Act are merely a minimum floor. Any and every agreement can, and in key areas should add additional protections that will further provide safeguards for individuals' data.
Thank you. Very quickly, Mr. Brinkel, Mrs. Rodriguez, 1 minute each.
I promise it's very quick. Just want to respond to your critical comment on the safeguards we have proposed. I think that when you look into the details of these safeguards we have proposed, they will protect the individuals. when we have asked for prior judicial authorization, we have asked to make notifying the actual citizen the rule. These are safeguards that definitely also protect the individual in that cases. That's absolutely the goal behind it. So happy to discuss this in detail. I mean, it's on the table. You know, we can just.
Yeah, and the problem of the safeguards, it's a complicated one. It's true that in Europe you have the GDPR, which is strong, but the problem that I see when I analyze laws in Europe and in Latin America is that sometimes the national laws are not adapting the legislation to match some of the recent court decisions, like the Teletube, for instance, decision on access to retained data. And that sometimes create like a lower standard than, for instance, the probable cause standard in the United States. Unfortunately, in the Cloud Act, the probable standard was not included in the document. It was seen by some, they said it's imperialist to improve a gold standard. I see a gold standard, the GDPR. I see a gold standard, the probable cause. It's imperialist to improve that. Let's invent new wording for the safeguards, and they use reasonable articulable facts. This is an unclear safeguard, which actually have legal meaning also in the statutes in the United States. What it means that now the US, instead of exporting a gold standard, is exporting still a lower standard, but it still comes from America statutes. So it's still imperialist, in my view. And so the safeguard is a problem. It's a problem in Europe, too. And there is a mismatch between the courts and the legislation. And we need to make sure that we can harmonize that to the highest level, because there are trends, the decisions, the courts are going into the right direction, while the laws are going against that. Thank you.
Okay, one last sentence, also in reply to Peter Swire. This is not just about standards. It's also, I mean, the US standards may be very high. The point is that I, as a European, I'm governed by these standards, but I have no influence over the democratic process. And quite frankly, the United States is hardly a banana republic, and it has a very robust judicial system. But if I look at the recent appointments to the Supreme Court in the United States and the way that also the lower courts have been politicized, I mean, I don't think that that would actually, I mean, if the US were to apply for EU membership, I mean, this would be an obstacle. You know, so in the end, it's not just about which standards apply, but also about the democratic process and in the way in which we citizens determine the standards. Okay, now we have to free the room. I would like to a big hand for all the panelists. Thank you all very much, and hope to see you at the next session.